Friends, we are all aware knowledge prospers all. So let's begin to understand another misconduct. Well, friends, we are going to consider the misconduct of negligence, that is, habitual neglect of work, or gross or habitual negligence. So, habitual neglect of work, gross or habitual negligence. This is what we are basically going to consider. Now, friends, we are going to divide this video into two parts. So, this is part 1, and the remainder with examples would be in another part. So, don't miss it. Friends, basically, what is negligence? In common parlance, also, we tell our friends, you are negligent, can't you do a thing properly? Is this the way you do it? But when it comes into industrial circles, it achieves a different sort of a momentum and a different importance. But basically, what is negligence? Negligence towards duty is a specific tort. T-O-R-T, tort. For those of us who don't know as to what is a tort, let me explain. A tort is a civil wrong. It is something which is opposed to civility. It's some indecorous behavior. In general terms, we can call it. But then negligence towards duty is a specific tort. Mere negligence involves a conduct which can be described as the failure to exercise the standard of care that a reasonably prudent person would have exercised in a similar situation. This is a general definition in the Black's Law Dictionary. So this is something that a standard of care which a reasonably prudent person, so you don't require an Einstein or you don't require a Newton to tell you as to what is this situation. No, an average prudent person. Who is an average prudent person? A person who is walking on the road is an average prudent person. He knows everything. So the test is, what is the standard of care he has to exercise, and if that is not met, then the person is negligent. Now, negligence is also defined as a breach of duty, which one would do or omit to do, or it is either a positive act or it is a negative act. So basically, what is your duty list and what are you expected to do? So what do you expect a person, or what do you ought to be doing? You do it, but you are negligent. So it could be a positive act as well as a negative act. You have to do it diligently, not negligently. So any job, when negligence arises, if there is a breach of duty arising, now this duty can arise out of, say, two, three ways. One is a contract. Say your appointment letter itself is a contract. Second is the statute, that is the law itself, or otherwise, a bit of an emphasis is kept on otherwise also. How? I will explain you when I tell you some examples of it. Now you see, there is another doctrine in negligence is, how much can you foresee a situation? Say, for example, you are a driver, you sit in the car and you understand there are no brakes. So you should foresee as to what would happen if there are no brakes. You go in full speed, there are no brakes. So as a prudent man, you should foresee that there could be an accident. Otherwise, you are negligent. So in simple words, it's the average prudent man's test, which is also termed up as a doctrine of foreseeability. Okay. I mean, what is the standard to determine negligence? One is, it's the conduct of a prudent man in a particular situation. The emphasis is on the particular situation. What is this situation? Maybe he is prudent, but he has to understand the situation also, because that is going to further determine. We are of course going to see some examples as to how a person is negligent. Now you see, if a man has a skill, say for example, he is a carpenter and another one is a simple painter. Carpenter and a painter are two different trades. So you cannot expect somebody who is a painter to be as skillful as the carpenter when it comes to carpentry. And vice versa, you cannot expect the carpenter to be an excellent painter. Okay, the skill sets vary. So when you accuse negligence, you have to see as to what is his skill set and how much you can expect out of that person. Now you see, burden or the onus to prove a person is negligent is of course on the management, and the management should show that it was a part of his job, and either by description or by practice or by past conduct, that yes, this person, this workman has done this job earlier. Before you fasten the charge of negligence on him, Because there are many times it so happens that the moment you charge him of negligence, he says, this is not my duty itself. So have you seen his duty list? Have you seen the practice? Have you seen in the past he's done this job 17,000 times, and today when he makes a mistake, he says, this is not my job. This would not be a plausible defense. Then friends, we see what amounts to negligence depends upon the facts of each case. It's not that two cases, they may be similar, but they are not identical. So it depends on the facts of each case, and each case determines what ought to be done. So there is a what ought to be done in the situation. Well, and that trade is different, work is different, job is different, everything is to be seen. Now you see, to pin the blame of negligence, there must be a duty to exercise care. Before you pin the blame that yes, you are negligent, you have to see as to what is the duty of care, and then care must be taken to avoid the acts or omissions. Say for example, you have some job and he is expected to do something which he does not, then certainly he is negligent. Okay, now in the name of discipline, see, the employer is not there to clutch a straw to style anything as a misconduct or to throw out the employee. No, anything cannot be negligence. Negligence is to be proved. Negligence has to be seen. In the maxim, in some of the earlier videos, we saw the maxim res espalocitur. Means what? The thing should speak for itself. You are negligent. Means what? I mean, it's not a subjective opinion we have. It's on the anvil of evidence also it has to be proved that he is negligent. And see, what is important ultimately, again coming down to square one, is the duty of care. How much care he has to take. The element of care varies from person to person. It varies from time, place and circumstance. And an employee who is doing a particular job, misconduct is something which is in deviation of the rules, how to do a certain job. And these are the parameters. This is the scientific way in which you do it. If you do not do it or you deviate from the scientific way, means why are you deviating? And then you make a mistake, things do not go properly, and then naturally you are pinned up with negligence. Then a person is negligent. Now you see, employee, the same skill set cannot be, as I told you, expected from a skillful worker and an unskilled worker. Normally the workers are of three types. One is a skillful worker, one is an unskilled worker, and one is a semi-skilled worker. Their pay packets also differ. Their basic wages also differ. And then what we see is a skilled worker cannot be equated with an unskilled worker. They are different in skill. That's why we call them skilled and unskilled. So the concept of negligence is also going to differ with both of them. The concept of negligence, remember one more facet, that it's negative in character. It's a person is charged for not doing something. That is negligence. Now the misconduct arises when the misconduct is in violation of express or implied conditions and obligations. So you first have to know as to what is the obligation. This is the periphery of your duty. And if you encroach somewhere else or leave that periphery, then you do something which is not warranted. And if there are mistakes, if something happens, then certainly a person would be negligent. Now you see, the employees are screened, they are trained, and then the liability is fastened and then it is fixed. This varies from the nature of employment and the responsibility. Say, and this is everywhere. It's not that only with workers. Say in corporate offices, timelines are given, deadlines are given. You complete this project within this time frame, and then the person does not do it. He is called clumsy, he is called maladroit, he is called inefficient. So many adjectives we are having. But ultimately what we are saying, he is negligent. Say in manufacturing, we see that mishandling instruments are very expensive. He drops the instrument, so many expensive instruments, and then naturally he is negligent. Of course, everything has to be proved, remember. And then negligence includes inadvertence and carelessness also. Not being punctual and forgetting something. Well, being punctual and all of those, some people are by birth absent-minded. So that again would be negligence if at all he comes into a responsible position. And moreover, culpable negligence lies in the, say, in the failure to exercise proper and reasonable care. Culpable is criminal. Sometimes you transgress the thing and culpableness would arise for want of exercise of proper care and caution. And then we are going to see so many examples. But what exactly is negligence? It's in the fitness of things. We understand it with examples. But of course, that's in the next video. Thank you so much.